Today's success story is about an executive manager coming to the United States, opening up a brand new office. It was a very difficult case because they originally wanted to apply for an E2 in a treaty trader, but we analyzed everything and they don't qualify for it. So then they now had to do the L1. But the funds were very limited. They invested just shy of $100,000 to start up this company. And in the bank account, there was only $12,000 left. And the person that wrote back to us and issued the request for evidence was the director himself. It was a brutal request for evidence. Our team worked really hard with the client and actually responded in a very short manner. And the case got approved. There was so much to learn from this case that I want to walk you through everything. So hopefully you can see exactly what's going on. Hi everyone, my name is Joseph and I'm the managing partner here at Tsang and Associates, where we solve legal problems with creative solutions. This was a very challenging request for evidence. They did not approve the 1-year employment abroad. They said the evidence of your organization submitted was insufficient because just having a letter from the HR was not enough. The next thing is that the US company has to prove that within 1 year, they will be able to fulfill and support an executive and managerial. It's not good enough just to prove that in 1 year, you will survive. It's not good enough just to prove that 1 year you will employ a few people and you will have some activities. You need to prove that within 1 year, the organization is big enough that it justifies an executive. Please provide all of these things. Letters from the foreign company, copy of feasible study, copy of business plan, minutes of the foreign company illustrating the discussions on how to improve the US entity, a proposed organizational chart, so on and so forth. They also want to talk about the size of the investment into the United States and the financial ability of the foreign entity to support the client and the business in the US. And then went through another 10, 20 bullet points of talking about what they wanted. Then they challenged whether or not the business is sufficient in size and scope. Show me the lease agreement. Well, we provided it, but here's all the reasons why it was not good enough, but you can still submit statements from the worksite, Salesforce, letters from the owners of the property management company, copy of the contract between the owner and the leasee, color photos of the US entity's premises, copies of escrow documents, copies of the entity's floor plans and interior design, including the office. Then they challenge whether the beneficiary is the owner and the major stockholder of the company, and please provide contracts, assignments, shares, statements from the foreign entity, and it goes on for a total of 8 pages. It was a very difficult decision on how to craft this response. One way to go about it is, okay, you give us 10 pages of request for evidence, we'll give you 40-page response to prove without a shadow of a doubt that the case was approvable. From our reading of the request for evidence, from our reading of this director directly challenging everything, and because the clients just didn't have that much to provide, our strategy was to quote the law back to the officer to show them what is necessary and what is a nice to have. You can request all these things, but the client doesn't have it, nor do they want to, nor is it necessary. We reiterated what we previously submitted, and we provided a few additional ones in each of the category. And we quoted the policy manual, we quoted case law, we talked about exactly what's necessary. This is what the officer is supposed to be looking at, what they're supposed to be adjudicating. This is what's provided. By the very nature of a new office, the officer, they don't have it, but the regulation does not require it. When the clients are able to provide a lot, we can use a lot and make an argument. But in this case, the client couldn't. There was only $12,000 in the bank account. USCIS has the authority to request these, and that's fair. That's what the officers wants, but we don't have to provide everything. So we explained why we didn't have certain things. We explained what we did have, and we furnished additional ones, and we crossed our fingers, because you never know what the administration is going to do. And we were very pleased to announce today that, again, this case was just approved. This case, done by Andy's team, so proud of him. We have a feeling that that was a brand new template that USCIS is using to challenge all L1 cases. And now we have a template on how to respond. With that being said, if you guys have any questions about L1, about B1C, feel free to reach out. Thank you. Take care. Bye-bye.